we're into the third bucket, harassment and conduct, anti-harassment training and policies. What do you got?
Me Too. It's, even before Me Too, the restaurant operators had a unique task in fighting off harassment claims because it's not an office, it's not a law firm, it's not an accounting firm where you're at cubicles and there's not a lot of situation for fun social interaction. You're in the hospitality environment. You're the workplace. You're also simultaneously for the customers trying to create a nice experience. So a lot of the times, and you'll have your employees in that experience, right? And so you come to a law firm, you're dressed stuffy. You go to a restaurant, the servers are not typically dressed stuffy, unless it's a stuffy restaurant. So you have all these unique things that make the environment a little bit different and that are more prone to harassment, right? I think Jason, you had him on the last one. One of his book is like, don't let someone on your couch or someone like that, or don't sleep with the hostess.
Please don't sleep with the host.
Yeah, well, that's right. It doesn't say please don't sleep with the secretary. It says please don't sleep with the host. Now, that doesn't mean that it's okay. There's one standard for all industries for anti-harassment law federally and state by state. They don't look at the industry and say, oh, well, it's a restaurant and there's alcohol being served, so it's okay that someone like this restaurant can have F-bombs fly because, it's not a law firm where you should be more buttoned up. No, the law doesn't work like that. And the law does not work in a way that says, well, they know what they're getting themselves into here. This is a sports bar. If they come here, they're going to get loud, drunk dudes. Like, no, it doesn't work like that. As a female.
They're working at Hooters.
Well, yeah, funny. Hooters is very, very unique in the law, but I won't even get into that. But, absent of Hooters, there's something way out there on the.
Is there really a separate?
There's a concept in the law that you're not there. You're auditioning for a role. You're not actually a server, but it's a role because the concept is so ingrained. You're auditioning for a role, so that's why at Hooters they make the argument they can hire females and not male servers because that's part of their whole concept.
It's part of their brand. Same for Twin Peaks.
Yes, I would make the same argument, but they're factual. And every time a client's asked me, "Hey, can we do it?" I've said, "You're not going to meet the standard," and so it's out there. So that's why when you're a customer, you're like, "How does Hooters get away with it? How does this person get away with it?"
I'm gonna create a new concept called banana hammocks.
That's right. Well, why don't you just do a melting pot? You could have this like sideways like pineapple here, and that could be the logo. First, you don't know if they're quote unquote getting away with it, whoever they are. A lot, there's really no black and the white in law, and so a lot of times, you're getting sued on it and settling suits, or you're figuring out a way on why this works for you as a concept. But that's the very, 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 very small percentage. Most of the time, it's like any other environment. You need to make sure it's a fair place for male and female. You need to make sure that when they come to work, it's not just that they're being hit on themselves, it's that the environment is not over-sexualized. A lot of states, including California, have harassment training requirements. And so I get this question all the time. Well, what happens if I don't train the people? Well, the first 30 days, they've got to be trained. Well, we're having an event, and then we're going to be dark for like 2 months. Like, I have to train them before the event? Well, yeah, you're hiring them technically, and
that's why you should block out an onboarding process where like the first week that they're an employee of yours, they go through the step-by-step process to make sure all these boxes are being checked.
That's right. And it's not just because then the next question, they say, well, what happens if I don't train them? What's the penalty? Well, there's no statutory penalty. It's not $1 million per employee if they don't get, for every day they're not trained after 30. What it is, though, is it's pretty bad evidence. If that employee is going to go do something and harass someone or engage in inappropriate conduct, and then, you're before a court, jury, arbitrator, I don't care who it is. And the question comes up, well, what employer did you do to let them know that, like, as a workplace, like, we don't tolerate this? I gave them an employee handbook. They tossed in the drawer, and I didn't even train them as I was required. That doesn't sound good.
Yeah.
But this isn't me saying train them just to comply with the law. It's to your point. It's to set the tone. Mm-hmm. You can have compliant anti-harassment training in a way that communicates your brand, your message, the tone, because all culture, what you're talking about is how you relate to your coworker. Yeah. And so, it's legalese in the handbook. A lot of times it says don't, do this because of their age, race, the long litany of protected classes, but it's also don't do it because don't be a dick. Right? Like it says don't yell based on any of these things, but don't yell because it's a bad management tactic. And so you can use that to ingrain the message.
Okay. And this is required by law to have these trainings in place now, as of recently or soon to be, but there was a little bit of a delay.
California, for years, has had the requirement that if you're a supervisor, meaning if you supervise at least one person, you have to have the training, anti-harassment training. They've now amended the law, California, to say anyone, supervisor or not, will have to have the training. That comes into play 2021, the effectiveness.
Okay.
A little bit of unique aspect about the timing. I've advised people, don't wait, train now. Don't wait for it to be a requirement. You're already training your supervisors. It's just as important as that at a line level, non-supervisor employee not engage in this behavior.
Okay. Now, there has to be a policy, a documented policy, and I think this anti-harassment or theft reporting system.
There has to be most states have requirements that you have to have an anti-harassment and a reporting policy. So
fraudulent or misconduct.
Yeah, it's a path that an employee can report the harassment. That's the concept.
They need to know what to do when it happens.
That's right. The policy, it's not just have a policy that says don't harass each other. It's a policy that says that if you do feel like you're being harassed, this is the steps you take.
Yeah,
exactly.
And that needs to be documented.
Yeah, and most states have laws that require investigations. I mean, I equate it to the NCAA. I'm surprised I went this far without a sports analogy, but the NCAA, it's self-investigation, right? If they think there's a violation, then they tell the school, you got to investigate yourself. It's the same thing with the employment law. If an employee says, I feel like I'm being harassed, the employer is under a legal obligation to then do an investigation. If not, harassment or not, the employer ran into trouble because they didn't respond properly. Mm-hmm. And so it's, again, back to the concept of don't just have a policy and throw it in the drawer. Have the policy, show it to employees, use it during the training, and then when someone complains about harassment, get that policy out and follow it, investigate.
Yep. And I'm going to give my friend over at Ethics Suite, Juliet Gus, a nod here. They have a process for reporting fraudulence and misconduct. It's a free service for your employees. So all you have to do is adopt this process into your business if you want to check that box. It's pretty powerful stuff there. So on to the fourth bucket.
That's right.
And 19 is the list. We're almost done, guys. We're almost there. Thank you this is a lot of important stuff. No offense to our guy over here, Aaron. It might be a little dry, but we have to get through it because it's so critical. And hopefully we've talked you out of opening a restaurant at this point. 19, leave a... that
was a real compliment that you just gave me. I can't tell. Okay, keep going.
No, you're doing great, man. You're actually making this a lot less boring than it could be. So I appreciate that.
There you go. Exceeding expectations.
Leave of absence. Get into it.
It's its own bucket because it's really tricky in restaurants. Yeah. Some environments, again, law firms, if someone's going to be absent, they call in sick. Okay, the place is going to get by. If you are a restaurant, you're watching your labor costs, you're scheduling people in a certain way, and if a server calls, all of a sudden you're down a server. That's a problem. Mm-hmm. And so restaurants, and then you have a documentation issue, right? Someone comes in and says, ow, my leg hurts. I sprained my ankle playing basketball over the weekend. Can I not have to cover section 8 over there that's got a lot, spread out tables? Can I do section 4? That sounds pretty innocuous, but what they're really doing is engaging you in the interactive process, and they're seeking a reasonable accommodation. Yeah. And all of a sudden now as an employer, you've got an obligation to respond a certain way. And so you've got to be aware that when employees come to you and they raise a medical issue at all, you have to think formulaically, okay, what protections or what rights do they have? What benefits do they have? Do they have paid sick leave? Okay, they've exhausted that. Are they asking for a vacation day? Am I going to grant it or not? I'm not going to grant it because they didn't give me 2 weeks heads up. Is it a disability? Have they given me a note? Or is it just they said they have a runny nose or they're hungover? Okay, they gave me a note. How did I respond to this? Did they get injured? Was it on the job? Did we give them the workers' comp form? All right, am I allowed to ask what the medical issue is? Most states you can. California, you cannot. And so, someone comes in and says, I hurt my ankle over the weekend, can I just roll napkins? You can't say, how'd you hurt your ankle? What you can say is, how long is your ankle going to be? Can I get a doctor's note talking about what the restrictions are? Not that you roll your ankle playing basketball or whatever, but the note that how does it impact work? And then the concept of, these extended leaves, right? If you're a large organization, you have the FMLA, Family Medical Leave Act, or the state equivalent, which says, sometimes unpaid leave for 12 weeks. And, it's a lot because someone could come back. You're holding a job open for 3 or 4 months sometimes. And,
yeah.
And so what happens, I see this mistake frequently, is that the employer will say, okay, their FMLA leave expired. Okay, Are they back? They're not back. Boom, they're fired. And it's like, they didn't come back from leave. Sorry, we gave them the FMLA leave. That's all the protected leave they have. They're fired. No, that's not all of it. You have, there's still an employee that's disabled. Just because they've exhausted or used all their FMLA leave doesn't mean they're not disabled. If you're disabled, the ADA protects you. A type of accommodation can be extended leave. And so at that point, you can't just say, I've satisfied the FMLA, now I'm free to terminate if I feel like it. You've got to look at the ADA and say, what do I have to do under this statute? Oftentimes, it's just recognizing it and it's extending it out a little more. If the employee's not going to come back because of whatever circumstances, then you're okay, because indefinite leave you don't have to grant under the ADA. But if you've got a situation where it's 3 months they're out, they've satisfied their FMLA leave, they've given you a doctor's note that says I'm going to be back in 2 weeks. If you terminate, and then the employee sues, you're going to have to explain why it was an undue burden to give them 2 more weeks.
Because due to the doctor note, it's
telling
only
you it's
reasonable up to this point.
That's right. They're giving you a timeline, and the timeline is something that, as a large organization, are you going to be able to say it's could I have done this or not? And so when you hear accommodations and you often think it's modified duty. Well, reasonable accommodation, I don't have to do that. They give you a note that says I can't lift anything more than a pound. And maybe the person also can't speak English in the back of the house. I have nothing to do for you. Sorry, nothing. You're fired. No, because then you go to, well, how long is this? It's 2 weeks. Well, the reasonable accommodation could be unpaid leave.
Okay.
And so that's the concept that the takeaway is on leave of absence, that under the ADA, when you have someone that's got a medical issue, it's impacting their ability to do work. You've got to ask yourself, can I give them unpaid leave as a reasonable accommodation before you move to termination?
Okay. And the reason the things to do to make sure that you can't do that is the doctor's note.
Ask for a doctor's note. I mean, at the end of the day, if you're getting into a he said, she said, or a dispute about what the medical issue is, that shouldn't be a conversation. It's the doctor note controls. But how you ask for it, give a form, right, from your HR department or your legal counsel that discusses and clearly asks the doctor for what you can ask for, and attaches the job description back to the job description. So in this situation, here's the job description: a server has to be able to lift, has to be able to X, has to be able to Y, has to be able to Z. You give that job description with a form to the server and says, go take this to your doctor. The doctor then can look at the description and say, okay, for 2 weeks the server can't do this, this, and this. Then it's clear as day when the server brings that back to you what you have to do.
Okay. What about exempt employees?
Same. There is no distinction here. Exempt or non-exempt, they can be injured or not. You have to still engage in your active process.
And if it's salary, can it be non-paid leave?
Yes.
Okay.
It's nuanced. If they perform any work during the day, though, you're going to have to pay them. And so on. If and that comes up a lot. So if you have someone on FMLA leave and they're an exempt employee, turn off their email. Don't give them the opportunity to do work. Don't be calling them.
Yeah.
Because not only is it, argument that they should be paid for that day, but that's one day that they didn't get their FMLA leave. So you're going to have to extend it on the back end.
Got you. Anything worth unpackaging beyond this with the leave of absence?
When you're going to terminate for an absence-related termination, tardies, absences, whatever it is, you better look at each absence you're holding the person accountable for and make sure it's not protected. Make sure it's not sick leave, not ADA leave, not FMLA leave, because that's what the lawyer is going to be looking at.
Yeah, AKA have your lawyer look at it.
Absence-based terminations are tricky.
Yeah, I would get a second opinion there.
Yeah, you catch someone stealing and it's on camera, that's a lot stronger than if you're saying you've been late 6 times.
Yeah, got you. Okay, so this is the last item. We did it. We made it through 20 of these compliances. Good job, guys, and thank you so much, Aaron. You've been talking a lot, and I appreciate you. Number 20, termination decisions. Get into it.
So the concept of, okay, I've decided as an operator, I'm no longer, this employee's not capable of rehabilitation. They're not going to be coached. What I'm expecting out of them, I'm not going to get from them. I've made the decision to terminate. Okay, so what do? They're at will, which means you don't need a reason. But at will is limited by the fact that you cannot terminate for something discriminatory or retaliatory. Discriminatory is anything that's a protected class: age, race, gender, sexual orientation, military status, veteran status, citizenship.
What if they smell bad?
Smell bad, probably okay itself, but smell bad could be, why do they smell bad? Do they smell bad because of a religious practice? Do they smell bad because you think something smells bad, but it's really like that's part of their race or who they are or part of inherently?
Yeah.
This comes up. It's not a black and white thing, right? It's tattoos is an area. So a lot of times you have policies that'll say, we're going to terminate you if you have like tattoos that are showing. Like they come in, they have tattoo, they don't have their sleeves on that day, and they're working the cash register, and they've got these gnarly sleeves and of tattoos, and they get terminated. And one of the tattoos is a cross, and the employee says, I got terminated because I was displaying my religious cross. That's religious discrimination. And the employer says, no, we terminated you because you showed your tattoos. Didn't matter what was in the tattoos. And then the employee says, well, show me all the other times you've terminated employees for tattoos. And so when you're making termination decisions, you want to be able to link it to something in your policies. That's why you have the handbook. And so, and also when you make the determination, create a piece of evidence. Email your HR team. The decision's been made. We're terminating. Because you'll see a lot of times employees will hear about it, and I might be terminated. Next thing you know, they take a medical leave, or they complain about something, and it changes the risk profile of the termination because the timing looks different of the story. Because it makes it look like, hey, the employee was fine, we were just warning them, and all of a sudden they complained about harassment. That's the straw that broke the camel's back that got us to terminate. That's called retaliation. That would be a wrongful termination.
Okay.
And the other thing is that even though you're at will, discrimination, everyone fits into a protected category. I make the joke if you're a young, healthy, white, straight male, but even then you can have reverse discrimination on any of those categories. So when you make the decision,
I think that you bring up a real serious thing where like reverse discrimination, where it's almost becoming like a bad thing to be a white male because you're the bad guy. You know what I mean? Like I feel like the minorities are grouping together as one sometimes and coming at the majority as the because. Is that weird to say?
No, I understand what you're saying. I think the better way to put it is that everyone understands their rights, and everyone realizes that the rights are protecting all of them. And so before it would just be you terminated someone and they thought, well, you know what, it's because of my race. And you think, well, the white guy's not going to think that. Whereas now everyone thinks that because we're in a highly racialized environment, right? We're in an environment that it's front and center, who we are, what we're doing.
Well, you look at like an ethnic restaurant.
Oh, right, exactly.
So any ethnic, whether it be, I'm not even going to get into it, but an ethnic restaurant, and you as a white male can't get a job there, is that legal?
No, it's not legal because it doesn't matter whether you're white or what side it is. The employer can't make decisions based on your ethnicity. Period. End of story. And so it doesn't place a higher regard on certain ethnicities. Age discrimination is a good concept for this. Age discrimination, federal law says 40 years old. You have to be 40 years old to be quote unquote old. But you're still allowed to sue for reverse discrimination. You could still sue as a 35-year-old, and your claim could be, I wasn't hired because of my age. I was too young. Prevalence of it, to your question about am I seeing it more? No, I'm not seeing it more. I think I see employers trying to do a good thing and trying to oftentimes like hire consistent with their brand, and sometimes it comes off as taking things into account that you're not supposed to be considering, like age, race, and all these other things. On a termination, though, the concept that I wanted to get to was that when you're terminating, you're going to have a reason. You're going to in the meeting you're going to explain the reason. You're being terminated because we caught you stealing. Okay. At the same time, I don't care what it is. You're not wishing harm on this person. And a lot of times you have managers terminating, and it's like that moment of power, and they're exerting the power, and that's not good for the organization. It's creating risk. It's being a bad human, but it's also creating risk because you're incentivizing the person they terminate to go get an attorney to go challenge it because you're being a jerk. You can terminate and still be consistent about what the reasons are. You weren't meeting our expectations, and be empathetic at the same time. And so a lot of times, they say, well, I caught him stealing. Why would I give him a separation agreement? I say, you give him a separation agreement because you'd still rather know that they're not going to sue you. Even though you gave them their meal and rest breaks, they still may sue you for it.
If you take the high road, it's always going to serve you.
Yeah, you take the high road, and it's often worth it. And you can still say, listen, you're terminated. Today's your last day. It's Wednesday. We caught you on camera stealing yesterday. At the same time, we hope you transition somewhere to be successful, and we'll pay you through Friday. Here's a separation agreement if you want to pay through Friday. Either way, here's your pay that we owe you, and if you want some extra pay, here's a separation agreement.
So I think the big things to take away from this is to stay away from the big, like the race, sex, gender, sexual preference.
Yeah,
What
make
are the big
decisions
ones again?
based on a legitimate business reason, not who the person is, but what they're doing.
Okay. And also we kind of skimmed over a little bit, but the importance of having your policies, right? And your company policies, like this is who we expect you to be, cleanliness, organized.
If you're going to terminate someone, ideally it's because they violated a policy. I mean, it could just be the performance policy. It could be the attendance policy, but it could be a specific reason. So yeah, having those policies in place so you can later prove we have a rule, we enforce it against you, not we just picked a rule out of thin air and we terminated you and it's really because you're African American or because you're old or because whatever.
I think hygiene is a good one because that's one that people, if they're just not taking care of themselves, if they're unpleasant because of neglect to themselves, like that's one that, like an example, if you got to put that in your policies.
Yeah, a professional appearance policy, personal hygiene.
Yeah,
I think the
uniform.
Uniform. The important thing there is enforce it equally because you don't want someone saying, well, you're only terminating this group of people. Only the women are being terminated if they have poor hygiene, but the men you're tolerating it, right? That would be discriminatory.
Got you. Anything else worth unpackaging with this termination decisions?
Have a process in your company, right? Understand who gets to make the decision, understand who puts in input, and then once the decision is made, who carries it out.
Okay, and we didn't touch on this, but the importance of having a witness?
It depends on the situation. I think if you think it could be dicey, yeah, it's good. But when you're having people in the termination room, you have to ask yourself, like, is it going to set off the employee, or is it going to cause the employee to think, like, why is this person here? And so a lot of it is about EQ, not the legal answer, and it's about being able to communicate what the reason is, but still trying not to have an explosive situation.
So basically, just be very factual. Like we discussed this. You acknowledge that we had this discussion, documented, and this is the reason why we have to.
I think the concept is that you're not trying to get them to agree with you.
Yeah,
you're trying to communicate. We have a standard here. It's a performance standard. We raised this with you. You weren't meeting it with regard to X, Y, Z.
Yeah.
And because of that, we decided to end the employment relationship. And so we're here to talk about how we're going to end it. If they start trying to get into like why, it's like, listen, we're not here to discuss the decision's been made. What we are here to discuss is the process and how we're going to go about it. And so we have your COBRA dot, and then you transition into the process.
Okay. And is the process long? Is it short enough to kind of just like list the bullet points that should be included?
Yeah, I think typically you want to ask yourself, return a company property, what the last day is, the final paycheck. You want to make sure it's evident to the employee and you're following the state law. Like, here's all your money for what you're owed. You want to make sure that if you're offering them a severance agreement that you're not using the money you owe them for work as the carrot. Like, that's being paid to them, and it's a severance payment. You want to be conscious of when you're doing it and how you're doing it, right? Don't do it, in the middle of a big customer rush.
Yeah.
Who does it? And then giving them a point of contact for after the termination. Be conscious. Are you just going to let them come back in the restaurant? I mean, are they going to be able to come in as a customer?
Setting those expectations.
Right.
Got you. One thing that comes up often on the show is when things aren't working out, a good way to look at it is, hey, like my job is to set the people that come to work for me up for success. If being here if you're not inclined to this type of work, if you're not like, if this isn't the right path for you, it's my obligation as an employer to get you off this path and help you find the next path. Do you think that is overstepping boundaries?
Yeah, I don't think it's. I liked everything you said up until the point that it's my obligation to find you something else.
Maybe not, but I guess the mentality
is that we want happy workers here. And if we're really running into issues, like you're not hearing me about something, you're not improving where I'm telling you to. Yeah, you can have the conversation of, are you happy here?
Yeah.
Don't have that conversation if you plan to terminate the person because you don't want to mislead them like they have the job.
Yeah.
But I do think it's okay to say like give the person an opportunity to resign sometimes if they want. Sometimes people are unhappy and they want to get fired so they can collect unemployment. Or sometimes they don't realize they're unhappy. And so it's okay as an employer to say, look, are you unhappy here? Do you want to talk about it? What is this? Do you feel like you can be successful here?